12. Eminent Domain. Eminent domain is the claim to sovereignty by the state over all the property within the state, and it is the assertion of the right to appropriate all or any part thereof to any public or state use deemed necessary by the state. Compensation for the appropriated property is normally given, but it is not regarded as a binding limitation on the state. Eminent domain is an assertion of sovereignty, and in Scripture is ascribed to God alone. Because of his right of eminent domain, God brought judgment upon Egypt, Exodus 9:22-29. Because of his right of eminent domain, God moreover gave the law of the domain to Israel and declared it to be for all the earth and to all people, for all the earth is mine, Exodus 19:5. This affirmation is again stated in Deuteronomy 10:12-14. And now, Israel, what doth the Lord thy God require of thee, but to fear the Lord thy God, to walk in all his ways, and to love him, and to serve the Lord thy God with all thy heart and with all thy soul, to keep the commandments of the Lord and his statutes which I command thee this day for thy good. Behold, the heaven and the heaven of heavens is the Lord's thy God, the earth also, with all that therein is. This fact of God's eminent domain is celebrated in Scripture as the ground for the confidence of his people. Psalm 24:1, 50 verse 12, 1 Corinthians 10:26-28, etc. The eminent domain of the state was not recognized in Israel, as the incident of Naboth's vineyard makes clear, 1 Kings 21, although it is prophesied as one of the consequences of apostasy from God the King, 1 Samuel 8:14. It is specifically forbidden in Ezekiel 46:18. The origins of eminent domain are in pagan kingship. The term, eminent domain, may originate in Grotius in 1625. Since then, it has had a significant development. More important, the concept did not originate with Grotius, and it became significant in Christendom only as natural law thinking was developed. Because the philosophy of natural law locates the ultimate law within nature, it therefore locates the sovereign power within nature also, with the result that sovereignty is ascribed to a temporal power. Quote, sovereignty, majesty, supremacy, etc., in the theory of natural law, not only means a particular form or quality of political authority, it also means political authority itself, in its own essential substance. End quote. According to Cochrane and Andrews, quote, the power of eminent domain is a sovereign, inherent power which cannot be contracted away or separated from the state. End quote. This power was not claimed by the original colonies and states, but did grow as a consequence of the natural law philosophy and the influences of English law. With respect to the theory of eminent domain in American law, a paragraph in William M. McKinney and Burdett A. Rich, Ruling Case Law, 1915, gives an excellent summary of the concept as it developed in the 19th century in the United States. 10. Eminent domain as exercise of sovereignty. It was the theory of Grotius that the power of eminent domain was based on the principle that the state had an original and absolute ownership of the whole property possessed by the individual members of it, antecedent to their possession, and that their possession and enjoyment of it being subsequently derived from a grant by the sovereign, it was held subject to a tacit agreement or implied reservation that it might be resumed, and all individual rights to it extinguished by a rightful exertion of this ultimate ownership by the state. This explanation of the basis of the power of eminent domain was adopted by several of the state courts in their earlier decisions. Grotius's theory, however, was not adopted by all of the other political philosophers. Heinesius, quoting Seneca to the effect that to kings belongs the control of things, to individuals the ownership of them, it was objected by some of the judges of this country imbued with the spirit of individual liberty that such a doctrine is bringing the principles of the social system back to the slavish theory of Hobbes, which, however plausible it may be in regard to land once held in absolute ownership by the sovereignty and directly granted by it to individuals, is inconsistent with the fact that the securing of pre-existing rights to their own property is the great motive and object of individuals for associating into governments. Besides, it will not apply at all to personal property, which in many cases is entirely the creation of individual owners. And yet the principle of appropriating private property to public use is fully as extensive in regard to personal as to real property. Accordingly, it is now generally considered that the power of eminent domain is not a property right or an exercise by the state of an ultimate ownership in the soil, but that it is based on the sovereignty of the state. As that sovereignty includes the right to enact and enforce as law anything not physically impossible and not forbidden by some clause of the Constitution, and the taking of property within the jurisdiction of the state for public use on payment of compensation is neither impossible nor prohibited by the Constitution, a statute authorizing the exercise of eminent domain needs no further justification. The question is largely academic, but is of some practical importance in deciding whether the United States may exercise the right of eminent domain within the District of Columbia, notwithstanding a provision in the Act of Cession that the property rights of the inhabitants should remain unaffected. It was held that as eminent domain was a right of sovereignty and not of property, the provision had no application." End quote. There are a number of interesting presuppositions in this paragraph, but we shall confine ourselves to two. First, the natural right of the state to eminent domain has been presupposed, and the 10th Amendment to the U.S. Constitution has been overruled in terms of it. There is no express delegation of eminent domain to the federal government in the Constitution, which means that it was prohibited to it, if the 10th Amendment has any meaning. But a prior right, a law of nature, is assumed, after Grotius, which grants to every state a supposed right which no law or constitution can alter. Thus, although the U.S. Constitution does not grant eminent domain to the federal government, and although the Act of Cession of the District of Columbia to the federal government specifically required, quote, that the property rights of the inhabitants should remain unaffected, end quote, this provision was held to have no application because of an absolute right on the part of the state. Second, this absolute right to eminent domain is derived from, quote-unquote, the right of sovereignty. Again, this is an amazing assumption, in that the U.S. Constitution at no time uses the word sovereignty, and in fact avoids it. The Puritan tradition reserved the word properly to God, and the separation of the United States from King George III made them especially hostile to any political revival of the concept of sovereignty. There is thus no right of sovereignty envisioned in the U.S. Constitution of 1787 to 1791. In terms of this claim to sovereignty and to eminent domain, no constitution and no law has validity, in that all legislation can be set aside by means of an assertion of a prior sovereign power in the state. No legislation can give citizens any immunity against a state wherein the courts maintain a doctrine of eminent domain, whereby every law is subject to rejection wherever the sovereign power of the state so decrees. Quite logically, the federal income tax legislation calls what the taxpayer is allowed to keep an exemption by the state, that is, an act of grace. All a man's property and income, his artistic and commercial products, are, in terms of this claim to sovereignty and eminent domain, the property of the state, or at the least, under the control and use of the state. Only as the sovereign power and saving grace of the triune God are asserted and accepted can the claims of the state to be the source of sovereignty and grace be undercut and nullified. In the United States, George Mason, author of the Virginia Declaration of Rights, specifically excluded eminent domain in that document. The Virginia Declaration states, quote, that no part of a man's property can be taken from him or applied to public uses without his own consent, or that of his legal representatives, end quote. This principle, ostensibly restated in the Fifth Amendment to the U.S. Constitution, was poorly worded and left grounds for the reintroduction of eminent domain. Not surprisingly, the assertion of the sovereignty of the state, a humanistic concept, led in the 18th and 19th centuries to a counter-assertion, the sovereignty of the individual, again a humanistic principle. For Bakunin, the state was a sham god to be destroyed. Bakunin's trust was in natural law, and he held that natural law knows no state or any theory of state, but only man. Quote, man can never be altogether free in relation to natural and social laws, end quote. Freedom does not consist in revolting against all laws, quote, insofar as laws are natural, economic, and social laws, not authoritatively imposed, but inherent in things, end quote. They are to be obeyed, said Bakunin. Quote, if they are political and juridical laws, imposed by men upon men, end quote, whether by force, deceit, or universal suffrage, they are not to be obeyed. Quote, man cannot revolt against nor escape from nature. Against the laws of nature, no revolt is possible on the part of man, the simple reason being that he himself is a product of nature and that he exists only by virtue of those laws. A rebellion on his part would be a ridiculous attempt. It would be a revolt against himself, a veritable suicide. And when man has a determination to destroy himself, or even when he carries out such a design, he acts in accordance with those same natural laws from which nothing can exempt him. Neither thought, nor will, nor despair, nor any other passion, nor life, nor death. Man himself is nothing but nature. His most sublime or most monstrous sentiments, the most perverted, the most egoistic, or the most heroic resolves or manifestations of his will, his most abstract, most theological, or most insane thoughts, all that is nothing else but nature. Nature envelops, permeates, constitutes his whole existence. How can he ever escape this nature?" End quote. If man is quote-unquote nothing but nature, then man's every impulse has the status of sovereign will. As against the sovereignty of the state and its right of eminent domain, anarchism holds to the sovereignty of the individual and the individual's right of eminent domain. Accordingly, Bakunin called for, quote, the negation of God and the principle of authority, divine and human, and also of any tutelage by a man over men, and for the negation of free will and the right of society to punish, since every human individual, with no exception whatever, is but an involuntary product of natural and social environment. End quote. Because, quote-unquote, man is a social animal, man is truly man only in society. Therefore, quote, social solidarity is the first human law, freedom is the second law, end quote. How can man live in society when every man is his own law? For Bakunin, nature being absolute, the natural order is of necessity the good and the true order. It follows then that, quote, 8. The primitive natural man becomes a free man, becomes humanized, a free and moral agent. In other words, he becomes aware of his humanity and realizes within himself and for himself his own human aspect and the rights of his fellow beings. Consequently, man should wish the freedom, morality, and humanity of all men in the interest of his own humanity, his own morality, and his personal freedom. 9. Thus, respect for the freedom of others is the highest duty of man. To love this freedom and to serve it, such is the only virtue. That is the basis of all morality, and there can be no other. End quote. If nature is the ultimate order, then nature must also be the source of true order. Bakunin's logic is sound, however false his premises. If the state is the true manifestation of natural law, then the state is that area where man will realize true life and true morality. If the individual is this true expression of nature and of natural law, then the anarchism of the individual and a society of anarchism represents true order. Anarchism and statism thus have been two rival humanistic claimants to the right to represent natural law and to claim eminent domain. It should be added that anarchism does not give land to the individual but to quote-unquote society, to natural man as a social group, so that eminent domain in anarchism is usually exercised by the social group, not the individual. As against the natural law philosophies, biblical law declares the sovereignty of the triune God and his sole right to eminent domain. All property is held in trust under and in stewardship to God the King. No institution can exercise any prerogative of God unless specifically delegated to do so, within the specified area of God's law. The state thus is the ministry of justice, not the original property owner or the sovereign lord over the land. Accordingly, the state has no right of eminent domain. The chronic humanistic quarrel between statism and anarchism cannot be resolved except by the rejection of both alternatives in favor of the triune God and his supernatural law. One final point. Many who grant the menace of statist and anarchistic eminent domain still balk at rejecting the statist doctrine for technological reasons. How else, we are told, can roads then be built and the airwaves controlled? The answer to a technological problem must be technological, not a theological surrender. Technology can, if freed from statist controls, make possible the simultaneous use of various wavelengths and channels by radio and television. A different kind of society will develop without eminent domain. That development is a technological matter.